With that, I want to welcome our speaker tonight, Mr. Rich Samp. He's a long-term Arlington resident and a retired attorney, and you may know him from his work in the county. He's the president of the Old Glebe Civic Association, and he has an avid interest in history. And he has a great story to tell us tonight. So I am going to turn that over to him.
Kathy, thank you very much. Kathy will be the one who will be running the slides for me. I don't have any of that technical expertise, and so I very much appreciate the Arlington Historical Society for putting this all on. The story of the integration of public schools, both in Arlington and the United States, is one that has been frequently told. It, I think, pretty much begins with the 1954 decision in Brown versus Board of Education. And it was a long struggle here in Arlington, but finally school integration began in February of 1959, and it was a lot smoother here than it was in other parts of the South. However, the US Constitution does not generally apply to private conduct. In particular, the basis for the Brown versus Board of Education decision was the 14th Amendment of the Constitution, which requires states to and local governments to provide equal protection of the laws. Well, a private school is not bound by the 14th Amendment because they are not a state or a local government. And however, really the issue of integration of private schools is closely connected to the issue of integration of public schools, because one phenomenon that occurred throughout the South following Brown versus Board of Education is that the closer a school district became to mandatory integration, the more likely it was that private schools would be set up on a segregated basis as a way of foiling integration. It really was not that much of an issue here in the Arlington area. For one reason, the Catholic Diocese of Arlington, immediately after Brown versus Board of Education, announced that it was integrating all of its schools. And the so-called prestigious private schools in the Washington area really had never officially been racially segregated. They, in fact, had very few Black students. I'm talking about Episcopal, St. Stephen's, St. Agnes in the district, St. Albans, and National Cathedral School. They had very, very few Blacks because very few African Americans were able to afford the tuition. But really, segregated private schools were never a big issue in Arlington, but there were some segregated schools that persisted, and it was thanks to the efforts of two African American families, both of whom lived in Falls Church, that they brought litigation that one of the schools they sued was here in Arlington, and the result of that litigation was a US Supreme Court case that for the first time announced in 1976 that it was illegal for private schools to discriminate on the basis of race. That was on the basis of a federal statute, not on the basis of the US Constitution. Why don't you go to the next slide, Kathy? This is a picture from February of 1959 of the first day of integrated education in Arlington. These were 4 African American students who were walking into what was then known as Stratford Middle School. And within a couple of years, most of the public schools in Arlington were relatively fully integrated. But other parts of Virginia and other parts of the Deep South reacted quite differently than Arlington did to the Brown versus Board of Education decision. In 1955, there was a group called the Gray Commission in Virginia, and it proposed a constitutional amendment which would do two things. First of all, the state would order the immediate closure of any school that integrated. And secondly, what it would do would say that the state would provide financial assistance to students to attend private schools in those districts that chose to integrate. So the result, not surprisingly, was that no public school system would be particularly eager to integrate. Arlington did make an effort in 1956 to move in that direction, but the state intervened and abolished the local school board so that it wouldn't be able to continue on that path. There was a group called Defenders of State Sovereignty and Individual Liberty that was established in Virginia, and they established 60 chapters around the state to fight school integration. There was one chapter, not particularly large, here in Arlington, and as a result, the provisions of the recommendations of the Gray Commission were put to a vote of the citizens in early 1956, and by a 2-to-1 margin statewide, the Gray Commission recommendations were adopted. The vote was actually in Arlington. There was a slight majority that voted against this, but statewide it was by about a 2-to-1 margin, and the result was that very little was done in the 1950s for integration in Virginia. Now, there were court actions that were brought to bring about school integration, and Arlington's integration came as a result of an order from a judge in Alexandria by the name of Albert Bryan Sr., and that is what led to the integration of Stratford Middle School that you see pictured here. There was certainly opposition within Arlington to the integration of schools. A local plumber by the name of Jack Rathbone, who was the head of the local Defenders chapter, decided that he would try to set up some white academies in Arlington. However, he kind of got off on the wrong foot. He named the school the George Mason Grammar and Academic High School, and they put up a sign on their school, and they spelled grammar G-R-A-M-M-E-R, and as a result, the school became kind of a joke, and it never really caught on, and so there never really was a school that was openly whites only in Arlington. If you can go ahead, Kathy, actually 2 slides forward here. This is a picture from the Washington Post from the early 70s of a school that at 820 South Carlin Springs Road. It may be tough to make out the name on the sign, but it says Bobby's School. And it was a preschool that went from age 3 through the 2nd grade. It opened in 1958, and it never announced that it was a whites-only school. However, from its opening in 1958 until the time of this lawsuit, the owners of the school, a couple by the name of the Runyons, never had a single black student at the school. And I think there is a fair amount of evidence that it really was intended as a whites-only school, and that was really the reason that it was opened. In fact, Mr. Runyon was a retired police officer in Arlington, and I have been told, I don't have any first knowledge of this, that he had been involved in the anti-integration movement. And he retired from the police force, and he built this building, and he applied to have it be used as a motel. And that was the plan. And then very suddenly, without any real explanation, Instead, he and his wife decided in 1958, just about the time that Judge Bryan was issuing his integration orders, to turn it into a preschool. And it opened with 5 students in 1958, but it gradually grew. And so that by the mid-1960s, it had several hundred students and was thriving. The school also went officially by the name of Bobby's Private School, and it seems to me that's a little bit unusual to say that you're a private school, even if you are, which suggests to me another reason to suspect that maybe this was opened as an intent to be a whites only school. Kathy, can we go to the next slide? This is a picture of the very same school that I took about 2 weeks ago. And in fact, it still operates on Carlin Springs Road as a preschool. It's now called the Fairfax Academy for Early Learning, but I should hasten to add that it is under new ownership, and that the owners who bought the school in 1976 quickly integrated the school, and it has been integrated ever since. This school was one of the 2 that was the subject of the lawsuit in the Runyon versus McCrary suit that got to the Supreme Court. And could we have the next slide? Actually, can we go? I guess I'm looking for the picture of the Fairfax Academy. It's got to be 2. It's got to be ahead of 1. And yes, there it is. The other school was called the Fairfax Brewster School. This is a picture that I have here that was a yellow page advertisement for the school. It was located in the Bailey's Crossroads area of Fairfax County. It's actually no more than about a mile from Bobby's school. It is just over the Arlington border. It's on Glen Forest Drive, which is a dead-end street that runs off of Route 7. And it had a very large campus. It was started in 1954 by a father and son who, it appears they really did have an interest in education. And by being started in 1954, this would have been too early to have been a white flight school, but it just shared one thing in common with the Bobby School, in that between the time it opened in 1954 and the time of this lawsuit in 1976, it never had a single Black student. This school also was thriving, and it had several hundred students between grades 1 through 6. Now, I guess we should go back about 3 slides, if we can now, Kathy, to go to the picture on the tricycle. Yes, our suit, the story of our suit begins in about 1972. This is a picture of a mother and father and their 2-year-old son. This picture ran actually several times in the Washington Post, as well as in Time magazine, as well as in Jet magazine. This is the McCrary family. Sandy McCrary on the right, is the mother, and this is her 2-year-old son, Michael. And she was looking for childcare in 1972. And she lived in Falls Church, but she worked for the Department of Navy in the Bailey's Crossroads area, and the nearest preschool to her was Bobby School. It was only several doors away. So she, in the summer of 1972, she called Bobby School, and in fact, she had heard good things about the school from one of her co-workers who had a child there. On the other hand, the co-worker said, I don't know if this school is integrated because there are no blacks that are in the class. So she called up and was somewhat wary, but they were pleasant enough on the phone. She tells me that her voice was not identifiably ethnic of any sort, so that the person she was speaking with didn't necessarily know her race. At the very end of the conversation, she said, oh, by the way, do you accept blacks? And she was told by the person on the phone, no, we've never had any black students and we never will. So she was understandably somewhat upset by that, but rather than following through with a formal application, she enrolled her son Michael in another preschool. But then because she actually was an equal employment officer with the Navy, she knew some civil rights lawyers. So she approached a group called the Washington Lawyers for Civil Rights Under Law and said, can you find legal assistance for me to sue this school? And she was put in touch with an attorney named Allison Brown, who was a famous civil rights attorney in the early 1970s. So Kathy, can we go ahead? There's a picture of Allison Brown a couple of slides ahead. That's it, yes. He actually worked full-time for the National Labor Relations Board. It really wasn't possible, unless you worked for a private foundation, to be a full-time civil rights attorney back in those days, because there was no way to win attorney's fees if you won your case. In that era, it was a everybody pays for their own fees system. So he basically, his day job was to work for the NLRB, but in the evening, he did a lot of civil rights work. He actually had, over the course of the years, 4 well-known cases that got to the Supreme Court. Perhaps his best-known one was one by the name of Harper versus Virginia Board of Elections in the mid-1960s, that established that poll taxes were unconstitutional. But anyway, he spoke to Mrs. McCrary and said, sure, I'll be willing to take on your case on a pro bono basis, no fees. But really, I want to be able to take the case up on appeal as well as winning it in the trial court. So it's more likely to survive through appeal if you have additional plaintiffs with you. So he said, why don't you try to find somebody else? So at that point, Mrs. McCrary started putting up posters saying, I'm looking for other people who might have been discriminated against by the school. And at that point, she, for about a month went by, she didn't get any takers, but then her babysitter told her one day, oh, by the way, somebody else who I babysit for complained to me that they were also discriminated against by Bobby's school, and you might want to get in touch with them. So those other people that they got in touch with were 2 people by the name of Raymond and Margaret Gonzalez, who also lived in Falls Church. They were recent immigrants from Trinidad, and they had a son who by that time was about 9 years old. When he was 6 years old, their son Colin applied to the Fairfax Brewster School, and they thought he had been admitted. They had accepted his application fee, and he was all set to start. And he had finished in a preschool as a 5-year-old and was looking to start in the 1st grade at Fairfax Brewster. He planned to go to their summer camp in the summer of 1969. And then as he was getting ready to go, he stopped by the school to visit. And then 2 days later in the mail received a kind of a cryptic letter saying, we're returning your application fee and your medical form. We're sorry, we can no longer process your application. And there was no explanation given. So at that point, they couldn't understand what was happening. Raymond, the father, called up the school and spoke to what he thought was the head of the school, who told him that, sorry, we are not integrated. You might want to try some of the other following schools that are integrated, but we can't take your son. At that point, she started applying elsewhere. Among the other schools she talked to was Bobby's school, the one on Carlin Springs Road. And she, in 1969, 3 years before the McCrarys had applied, got the same no blacks response that the McCrarys had gotten. So at that point, they were able to find a private school that would take him. It was Congressional School in Falls Church, is where he started. But they were incensed, and Raymond Gonzalez called up the Department of HEW and said, I want to complain. And he was told by somebody on the phone at their civil rights office, we're very sorry, but while it's illegal for public schools to discriminate, there's no law that prevents private schools from discriminating. So they were upset, but they thought there was nothing they could do about it. But when they were contacted by Mrs. McCrary in 1972, they said, sure, we'll join a lawsuit. And so now that there were now two plaintiffs, they went back to the attorney here, Mr. Allison Brown, and said, okay, we're ready to file a suit. So he filed suit on their behalf in December of 1972 in federal district court in Alexandria. Actually, it was two different lawsuits. In one of the suits, the three members of the McCrary family sued Catherine and Russell Runyon, the owners of Bobby's private school. And then the three members of the Gonzalez family sued both the Runyons as well as Fairfax Brewster School, because they had been turned down by both schools. And so these were separate lawsuits, but they were consolidated together. And Kathy, can we have the next slide? You have to keep going forward. Yes, their case was assigned to a judge in Alexandria by the name of Albert Bryan Jr. And he was the son of this was 1972, he was the son of the federal district judge who had ordered Arlington's school integration 15 years earlier. Actually, Albert Bryan Jr. Only passed away last year, and what I have here on this slide is a slide commemorating him at the time of his death last year. He was somebody who was a no-nonsense judge, and he decided that he wanted cases in Alexandria to get to trial very, very quickly. So he didn't really allow very much discovery, depositions, and interrogatories and things of that sort. So ever since he got on the bench in Alexandria in 1969, Alexandria's federal court became known as the Rocket Docket. Cases were heard very, very quickly. So even though this lawsuit was not filed until December of 1972, it came up for trial in July of 1973, a mere 7 months later. Now, both of the schools involved denied that there had been any conversations in which they said anything about excluding blacks. They denied that they discriminated against blacks. So their main defense was, we didn't do it. But as I mentioned earlier, there were more and more whites-only schools throughout the South that were openly discriminatory. And so there was a group by the name of the Southern Independent School Association that represented several hundreds of these schools, and they were aware of this lawsuit. And so they decided to intervene on behalf of the defendants in order to uphold the right of schools to discriminate. And I think there were studies in this time in the early 1970s that showed there were an amazing number of students in the Deep South who attended whites-only private schools. By about 1972, the estimate was, I think, that there were more than 150,000 students in the Deep South who attended these schools, which ended up with something like, let me see if I get the figure, I'm sorry, 750,000 who attended these schools. And that amounted to about 10% of the white student population in the Deep South attended whites-only schools. So this group, the SISA, intervened, and they presented evidence in trial which purported to show that students performed better in school if they went to racially segregated schools. And they also argued that there was a constitutional right for parents to associate in private schools with anybody else that they wanted to, even if it meant racial discrimination. So their defense was a little bit different than the two schools whose principal defense, as I said, was we didn't do it. The case came to trial before Judge Bryan in July of 1972 and 73, and Judge Bryan made factual findings against the two schools. I think the strongest piece of evidence, as far as he was concerned, was that these schools had been around for nearly 2 decades, yet they had never admitted a single black student. On the other hand, there was also the letter that had been written by Fairfax Brewster returning the application that had been submitted by the Gonzalez family, and there was no explanation given. So he said that the failure to explain themselves was another evidence of racial discrimination. Plus, about 4 or 5 people testified at trial that they made the same telephone call that Mrs. McCrary made to Bobby's school, and every single one of them was told, "We don't admit blacks." So that was pretty strong evidence against the schools. Now, the biggest issue really in the case was not the factual issue, but rather, does federal law prohibit discrimination by private schools? And there was a law that is popularly known as Section 1981. It is part of the Civil Rights Act of 1866. It was passed right after the Civil War. It had been around for a century, and what it basically says is that all persons shall have the same right to enforce contracts as are enjoyed by white citizens. And there was a fair amount of case law suggesting that what this law meant was that courts in the South had to be open to blacks to enforce contracts, and that it really didn't apply to discrimination by private individuals, such as discrimination by private schools. Nonetheless, Judge Bryan interpreted the law as, yes, it did apply to private schools, and so he ruled in favor of the plaintiffs. By this point, the plaintiffs had already placed their kids in other schools and really didn't have interest in going to those schools, but he awarded several $1,000s in damages against the schools. Now, one of the wonders to me is, why did these schools keep fighting or even go to trial? They could easily probably have settled the case by paying several $1,000s or paying the judgment that was entered by Judge Bryan, and it cost an awful lot more to keep litigating this case to the Supreme Court. I talked to one of the board members of the Fairfax Brewster School at the time, and he said the people on the board honestly felt that this was the death of private education. If the courts could get into telling schools who they couldn't admit and didn't and could exclude, and that while the board members told themselves that they were not discriminating on the basis of race, they certainly wanted, they said, to preserve that principle. And so an appeal was taken to the U.S. Court of Appeals for the Fourth Circuit. Why don't we go to the next slide, Kathy? And this is a picture of the courthouse in Richmond where the appeal went. My understanding is that a portion of this court predates the Civil War and survived the fire in Richmond in 1865. Now, the Fourth Circuit at that time was much more conservative than it is right now. So the outcome was not at all clear when it went up to appeal there. The court did an unusual thing. Normally they hear cases in 3-judge panels. Instead, the court decided to hear the case en banc, meaning that all 7 judges on the Court of Appeals heard the case. And by a 4-3 vote, the court affirmed the judgment of Judge Bryan. The 3 dissenters were quite vociferous in their dissent. First of all, they said this law, Section 1981, doesn't prohibit private discrimination. And secondly, they said, we think that this is a violation of the First Amendment right of association of parents to be able to send children to the schools of their choice. At that point, the case was already getting quite a bit of attention, and schools in the South were very concerned, the whites-only private schools, about their continued ability to operate. So they took an appeal to the U.S. Supreme Court. And Kathy, why don't we go to the next slide? And this is a picture of the 9 members of the court as it existed in 1976, when the case finally reached the court. Back in the 1960s, the much more liberal Warren-era court had very broadly construed some of the provisions of the Civil Rights Act of 1866. And so based on those decisions, one might have expected the court to also broadly construe Section 1981 and say that it prohibited private discrimination. But in the years after those Warren Court decisions, there were 5 new members of the court who were appointed. The front and center is Chief Justice Warren Burger, appointed by Nixon, and the 4 in the back were appointed either by Nixon or Ford. They are from left to right: Rehnquist, Blackmun, Powell, and Stevens. And while later in their careers, Blackmun and Stevens became much more liberal, at the time they were still relatively conservative. So I've looked at the papers from the Supreme Court as it was deliberating the case, and there was serious question as to which way the court was going to rule. There was no sympathy on the court for the idea that there was a First Amendment right to attend a discriminatory school, but 6 of the justices gave serious thought to reversing and saying that Section 1981 was not applicable. Those 6 were the 5 Ford Nixon appointees, plus the justice on the front left, Byron White, who had dissented from many of the Warren Court decisions. In the end, though, the court issued its decision in June of 1976, and it ruled 7-2 in favor of the McCrary and Gonzalez families. And the only dissenters were Justices Rehnquist and White. Interestingly, the case got a lot of attention during the 1976 presidential election, and both of the 2 Republican candidates, both President Ford and his challenger Ronald Reagan, said they thought that probably, while they opposed segregated schools, that probably that white parents ought to have the right to send their kids to segregated schools if they wanted to. On the other hand, the U.S. Department of Justice, which at that point was led by Solicitor General his name is escaping me. He was the Solicitor General who was later appointed unsuccessfully to the Supreme Court in 1987. He wrote an amicus brief supporting the plaintiffs in the case, and that brief may have made the difference there. Yes, somebody just said Robert Bork. It was Robert Bork who wrote the brief on behalf of the McCrarys and the Gonzalez families. Now, the two schools reacted quite differently to the decision. The Fairfax Brewster School decided that, yeah, we never felt we were racially discriminatory to begin with, and we'll make more of an effort to have black students. And they did start admitting black students, not many, but they had some. The Reese family that owned that school owned it until 1988, and the school was integrated. On the other hand, the Runyon family that operated the school on Carlin Springs Road decided that that they had enough. They put their school up for sale in 1976, and they sold it several weeks before the Supreme Court ruled. And the new owners did integrate the school, but the Runyons were not going to have any part of integration. And there are some quotes in newspapers from that era, not quoting the Runyons directly, but quoting others as saying the Runyons didn't want to own a school that had to be integrated. I wanted to give kind of an interesting postscript of some of the things that happened after the decision. Can we go to the next slide? This is a picture of Colin Gonzalez. He was the 6-year-old who tried in 1969 to be admitted to the two defendant schools and was denied. He was 9 by the time the case, he would have been, I guess, about 12 or 13 by the time the case got to the Supreme Court. So he was aware that he was the subject of a Supreme Court case, and was always very proud of that fact. He ended up attending Northern Virginia Community College, where he studied photography. He now lives and works in Prince William County, as do his parents. They're still in that area, and they're also very proud of their contribution to the lawsuit. And can we go on to the next slide? This is Michael McCrary. Michael was a 2-year-old in 1972 when the case was brought. He was, I think, about 6 by the time it got to the Supreme Court, so he has no recollection of it. However, he went on to become a football star, first at Marshall High School in Northern Virginia. Then he got a football scholarship to Wake Forest, where he was a star for several years. He then had a 10-year career in the NFL, 5 years with the Seattle Seahawks and 5 years with the Ravens. This is a picture of when he was a defensive end for the Ravens. He led the NFL over a 5-year period in sacks, twice made the Pro Bowl, and was the he was a star player for the 2001 Baltimore Ravens team that won the Super Bowl. I guess, can we go on to the next slide? And here we're just back to the Fairfax Academy of Early Learning. I just wanted to talk a little bit about the school. It was bought by a woman by the name of Norma Brill in 1976. She closed on the sale in June, and only did she found out 2 weeks later when the Supreme Court ruled. She found out for the first time that the school was subject to a Supreme Court suit, which, needless to say, did not make her very happy. She immediately changed the name of the school. The school was integrated, and the school is still operated by her 2 daughters today, and I think it's only a preschool. It doesn't operate through 2nd grade anymore. At one point, she decided to expand the school and get more rooms, so she actually bought the Fairfax Brewster School a mile away from the Reese family and operated that school until she sold it in the year 2000. But the school was having declining enrollment, and it was extremely valuable land. So it was sold by the new owners in about 2003, and it was residentially developed and now has a bunch of houses where the school used to be. But the Fairfax Academy for Early Learning continues to thrive. Sandy McCrary told me that she visited there sometime after the court case and was very pleased to see how well the school was integrated. Can we go to the next slide? And finally, just to go back to, this is the picture of Allison Brown again. He was the attorney in the case. He took it all the way through the Supreme Court. The one issue that the Supreme Court did not rule in his favor on was, he said, maybe civil rights plaintiffs ought to be able to get attorney's fees in cases like this. And the Supreme Court said, no, if Congress wants to change the law in order to allow for attorney's fees, it can, but you get nothing in fees for the case. So he spent his long career doing civil rights and virtually never received a fee for his work. As I mentioned, he had about 4 or 5 major victories in the Supreme Court. But one result of this case was that about a year later, the the Congress passed a law called Section 1986 that says that prevailing plaintiffs in civil rights cases can get attorney's fees. So as a result of the denial of fees in his case, future civil rights lawyers can get fees. So with that, it's 10 minutes of 8, and I said I would leave time for questions. So I will conclude the presentation. I'd be happy to answer any questions people might have.
Oops. We're going to start with Jessica. I know we had some questions, so we're going to start with Jessica unmuting, and she'll ask you the questions that were asked during it, and then we'll open it up to others. And thank you very much. It's a really interesting story.
I agree, and I just wanted to, this is Jessica, I wanted to let everybody know that in the upcoming Arlington Historical Magazine, Mr. Samp has an article about this case, and I hope you all will read it. So please post me some questions. I don't have any right now.
Oh, you don't? Okay.
No, someone asked about where African-American students went to school prior to Stratford's integration. And we had some very knowledgeable respondents say Hoffman, basically Langston in North Arlington.
Was the elementary, yes.
The elementary, and Hoffman Boston was the high school. And in South Arlington, there was Kemper School. And that also fed into Hoffman Boston.
Okay.
I think Hoffman Boston remained open till about 1964. The reason there were only 4 people who were admitted initially in 1959 was that Judge Bryan said he was a little skeptical about having integration right away, because he said, well, what happens if the African-American students aren't up to the standards of the white students? And so he kind of made them people take admissions tests to get in, and only those students who passed that test were admitted. But eventually he changed his mind and said, no, everybody can attend integrated schools.
Okay, we do have a question. Oh, go ahead, Kathy.
No, do you have a question? Go ahead.
Yeah, Joni Guerra asked, what swayed the Supreme Court judges to make the decision that they did?
Well, as I was reading the papers, as I mentioned, 6 of the 9 really wanted to rule the other way, but there's a term in the law called stare decisis that says that courts are really supposed to go along with old decisions, and they looked at some of the 1960s era decisions that had involved other portions of the Civil Rights Act of 1866. And those decisions had said that the law was intended to apply to private conduct. And so at the end of the day, the judges said, well, it's really too late for us to make an independent judgment on this statute. We really need to follow the decisions from 10 years ago.
Okay. Margie Samp asks, what happened to the 750,000 students who attended all-white private schools in the Deep South? I'm assuming the schools all had to integrate.
Well, yes and no. Many of those schools continue to exist. However, first of all, they could no longer deny admission to Black students, but what they could do, of course, is continue to charge admission, and they also, because of their history as whites-only school, probably didn't get a whole lot of Black applicants right away. But between this case and also the IRS started revoking the tax-exempt status of many of these schools, it became harder and harder for schools to operate. If you don't have tax-exempt status, it's very uneconomical to try to operate a school. And so there are still schools that are largely white. The IRS said if you want to get tax-exempt status, one thing you have to do is you have to start some affirmative action programs, and you have to offer scholarships to make up for the fact that you were all white in the past. Otherwise, nobody will apply. And so there are, I would say, these schools probably have less than 100,000 students right now, and all of them have a history of at least some Black students.
Okay. Tracy Hopkins asks, were other private schools in Arlington also segregated at that time?
I'm not aware of any. The Diocese of Arlington stopped all segregation after 1954. So, for example, one of the plaintiffs in this case, Colin Gonzalez, ended up going to an Arlington Catholic school, not right away in the first grade, but I think he started in the second or third grade. So that was certainly a good source of integrated private schools. And I'm just unaware of any schools that were segregated, and certainly after 1976, none of them would publicly have said that they were segregated. Okay.
Barry Davis asks, how prolific were private schools in Virginia prior to the time of massive resistance? He says, I know in the Hampton Roads area, there were very few until the late 50s.
That's correct. Public education was kind of a newfangled thing in the 20th century in Virginia. A lot of well-to-do people were privately tutored or had small private schools of their own, but no, there were not many private schools. Probably the biggest and most famous of the private schools was a school called Prince Edward Academy. Prince Edward Academy was kind of the poster child for massive resistance. The Prince Edward County in south side of Virginia closed all of its schools for 5 or 6 years, and they had at their height 800 or 900 students, and they were getting subsidies from the state to have students attend there. But then eventually the Supreme Court in 1964 ordered the Prince Edward County to reopen public schools.
Okay. David Ansel asks, where did the students who weren't admitted to Arlington and Falls Church preschools wind up going to school?
There were integrated preschools and babysitting services available, so that Sandy McCrary told me that she had no trouble finding a preschool. And as I said, there were definitely integrated preschools in Arlington, although I suspect that preschools and kindergartens were not all that common back then. Arlington had only started half-day kindergartens a few years before, and so that it was not unusual for kids just not to go to preschool.
Okay. All right. Michael asks, how was the decision by the Catholic schools to integrate received by Arlingtonians?
I've spoken to one or two people in the diocese, and they frankly were a little bit hazy about the history. They knew that there had been an order for integration. There was never any resistance among parents at the Catholic schools to integration, but then again, I don't believe, given that there were not that many African Americans who were Catholic, there were not that many applicants. And again, of course, they would have had to pay some tuition, not nearly as high as the tuition at schools like Episcopal, but the tuition may have kept them up. So the result was that, yes, the schools were integrated, but there didn't seem to be any objection, just as there really was no objection to integration of public schools among Arlington parents. And I think that's one reason that perhaps it was easier for parents was the African American population was just not that large in Arlington, so that unlike in places like Prince Edward County, where the population was well more than half Black, if you have a population that is less than 10% Black, it's going to mean that every class is probably going to have a few African American children, but it's not going to be a majority, and that was perhaps less threatening to white parents.
And if I might add to that, when the chink in the armor, when we had a speaker and he spoke about the fact that that was one of the reasons why Arlington was a good place to try the integration, because of the size of the African American population in the county. He wrote an article called "A Chink in the Armor," and it's about Arlington's story to desegregate. It's a great article about that.
Some of the information from this talk comes from that article.
Yes, it's a great article. At this point, I think that, and Jessica, unless you have more questions, should we offer that anybody else wants to unmute?
Let me just ask one more question and then we can unmute. Bill Fogarty wanted to know, was the Supreme Court case ever used as precedent for subsequent Supreme Court issues?
All the time, although not really anything to do with school segregation, because what the case held was the statute, Section 1981, prohibits private discrimination in contracting. And of course, there are lots of contracts that take place all the time. There was a big Supreme Court case just last year involving a Black television impresario who was suing several of the large cable operators under Section 1981, saying that he had a right to have his stations carried by those cable companies. And if you are suing for racial discrimination in employment, you will, of course, sue under under Title VII of the Civil Rights Act of 1964, but any good plaintiff's lawyer will also include a count under Section 1981 because it adds to the potential remedies you can get. Interestingly, in 1988, the Supreme Court was considering overruling the Runyon case because perhaps the court was more conservative then, and it had an employment discrimination case before it, and it was thinking of using that case to overrule Runyon, and so it asked for briefing on that issue. It should be overruled Runyon. So there was a lot of friend of the court briefs that were filed in that case, including one by a woman by the name of Sandy McCrary, the plaintiff in this lawsuit. By that time, she was attending George Mason Law School at nights, and so she wrote her own brief and told the story of her case in her brief and asked that the Runyon case not be overruled. And the court issued a decision later in 1989 that slightly cut back on some of the remedies available under Section 1981, but it unanimously affirmed the Runyon decision.
At this point, if anybody else would like to unmute and ask any further questions, we would be happy to hear from you.
I'm sort of interested in how you got interested in this topic.
Well, I think all of the lawyers who are here in the audience probably are well aware of the Runyon case. It's a famous case, and I've been somewhat interested in it, but I was just doing some legal research on a unrelated matter about a year and a half ago, and that was the first time that I realized that the case originated in Arlington. And so that got me thinking, well, maybe I could, while all the people in the case are still alive, I can talk to them all. And luckily I have a brother-in-law who works for the Los Angeles Times, so he was able to do some advanced searches that located telephone numbers for everybody around the country. And everybody I called up was quite willing to talk to me, although the one thing they said, how did you ever find my telephone number? But we're very happy to talk to you. And so I spoke to just about everybody who is still alive. I spoke to, and if I didn't speak to them, I spoke to their children.
Okay, if we don't have any more questions, I'd like to thank you, Rich. What a very informative presentation. We really appreciate your time and your research and bringing to light this story in Arlington history. I thank all of you that have spent the evening with us, and we hope that we will see you on future AHS events. Check our website out, our social media, and please make sure to join us again.